address it. I have a lot of information that I want to cover in the next probably 45 minutes or so. And I will be raffling off 2 movie tickets because this is Valentine's theme, and we're celebrating love, and we're celebrating family and relationship. And because you have chosen to attend, I would love to give you a gift. Everybody who attends today also is going to receive a discount consultation link, which we'll get back to at the end. So if you want to talk to me one-on-one about the specifics of your life and your circumstance, I will be very happy to talk to you. Hopefully everybody can see my presentation. If you can see it, can you just put in the chat, I see it? That will help me, or just a thumbs up or anything to let me know that you can see the presentation here that says Peace of Mind Planning Workshop. I just want to make sure that everybody can see. As of now, nobody can. Okay. I'm like, nobody can see. All right. I see you guys. I see you. Thank you. Okay. Perfect. Thank you. Okay. All right, so we're going to get started. So again, welcome to Peace of Mind Planning Workshop. This is about your life, love, and legacy. And I am excited to be your presenter. Hopefully, I'm always asked to do presentations, and every time they're always virtual. Every time I have some like difficulty navigating through slides and things. So I'm asking you in advance for your grace as we're trying to get through these slides and cover this material. Okay. So you may be asking yourself, like, what are we talking about? What is this whole thing about? Yes, it is about estate planning, but what even is that, right? So when we hear that term, a lot of times we automatically think about death, and that's really not all we're talking about here. So these are the topics that I hope to cover in the time frame that we have. And again, as questions occur to you, feel free to put them in the chat and I will do my best to address it. Okay. So what we're talking about is why planning matters for every stage of life. So you see that this says life stages and not only for death, okay? What happens in our state without a will? But just know that if you're not in the state of New Jersey, it's pretty much the same in every state. How to protect your family, assets, and benefits, the core legal documents that everyone needs, and finally, we're going to talk about the costs, next steps, and your path to peace. Okay. All right. Ooh, I see somebody in the waiting room. We're going to let them in and we're moving right on. So I want you to honestly answer this question. And if you can drop your word in the chat, that would be great. And if there's a word that I didn't consider that you want to put in there, that may be fine. Some of you may be, your family will be perfect, but if something unexpected happened tomorrow, would your family experience peace, confusion, or uncertainty? And don't be ashamed, just write it in the chat. Again, if you have another word, you can do that as well. And this doesn't only mean death, because all sorts of things happen in life, change in mental status, birth, of course, death, loss in employment, all sorts of things can occur. And what would your family have experienced if any one of these unexpected circumstances were to arise in your household? So I'm hoping that my word would be peace, and I'm probably am hyper concerned about this for my family. So I tend to like make, in addition to my estate planning, I'm like always updating a note that I have for my family that's available in the cloud that they can always see, and they can always get answers to questions. But I see nobody wants to answer this. So I'm looking in the chat and it's like silence, and I understand. That is okay. If you don't put it in the chat, at least think about it in your mind. Honestly, you don't have to tell me, but you really should consider it yourself. Would your family experience peace, confusion, or uncertainty? And this is about what would they do? How would they make ends meet? If you are the person that they're relying upon for financial security, is there a backup plan? These are all things that you want to think about. Okay. Let's go to the next slide. I feel like I did. I'm like, I don't know how I got this far, but again, thank you everybody for enduring with me and my technical difficulties. Okay, all right, let's get back to where we want to go. Here we are. Okay, you need a plan. If you have, some people think, well, I'm not wealthy, I don't have much, so there is no need for me to do anything. My family will know what to do, or even if they don't exactly know what to do, they won't have much to deal with. But the truth of the matter is, you need to have a plan. If you have loved ones who depend on you, a home, real property of any sort that you own, bank accounts, believe it or not, a retirement, which most of us have at least a bank account, medical wishes that you want honored, or you desire to help your family avoid conflict in the future. You may be the peacekeeper in your family. And just think about if what the circumstances may be if you, the peacekeeper, are not there. Okay, so these are things that you want to be thinking about when you are considering, do I need a plan? More than likely, the answer is yes. Okay, now here are some life moments um, to be a trigger for you. So if you find yourself or your loved one experiencing any of these key moments in life, it is a reason, it should be a red flag to remind you to think about, what do you have in place? What plan have you established? So here are some of the moments: marriage or partnership. If you have a legal partnership or marriage relationship, this is important. And sometimes people actually think that once you get married, you no longer have to plan, because this person obviously is the person, and that's all everybody in the world needs to know. But the truth of the matter is, that's not how it works. So even in banking and in retirement, receiving of retirement benefits, and a myriad healthcare, a myriad of other things. Marriage alone is not enough to give authority to that person to act on your behalf. Many places require that your spouse has something in addition in writing to give them authority to make decisions on your behalf. And believe it or not, this is even in the case of a bank account. Many people think, oh, well, we have joint bank accounts, so that means that my spouse, if something were to happen to me, has access to the full of the bank account. And that's not necessarily true. It really depends on the type of joint account that you have, and if there is a pay on death designation. These are things that when you go to the bank, they don't tell you. And most times we don't do it because we think joint bank account is enough, but it's not enough. And this is whether it's for you have a joint account with a spouse or with one of your children or a trusted friend. I have had folks come to me after the death of a spouse or a partner, and they thought that they would be able to access a whole bank account, but they were not able to, and the bank froze half of it, and they had to go through probate. Okay, so key moments: marriage, partnership, the birth of children or grandchildren, buying property, even starting a business. When you have a business, a lot of times people don't realize that that also has to be considered in the winding down of your life or your estate, whether it is because of your death or because of your incapacity. You have to have thought through, what happens to my business? What does my organizational document say about that? Does it match with my what I would like for my estate plan, or what I've put in place for my estate plan? These are considerations that it's very easy. We go online, you get an LLC, you start your business, and you give no thought to what happens at the end. What happens if something unexpected occurs? And especially when you're a solo or a individual who owns a business and you don't have a partner, it's very, very important in that instance to make sure you have things in place. Okay, so starting a business is, as you start and you're excited and you're about to start making your money, or you're about to start hiring, you need to at the same time be thinking about the end of a thing. Okay, in the event of divorce and blended families, the blended family thing I'm going to come back to. It's really significant, and it's another thing that we don't know is significant. The law says that if there is no will in place, that your spouse and the children of another relationship have to split everything. And again, many people don't know that. So we are going to get back to that. But the blended family situation is an immediate trigger to say, okay, let's sit down and talk through the planning of our life and circumstances. Okay. And love is enough in many cases, but in the situation of legal planning, it is not. Okay. So just because you love someone or you love children or whatever, if you have to make sure that things are put in place, because if not, even if you love them, the state says what happens. Okay. Other key moments to be triggers: illness, disability, aging parents, even your own aging, or caring for someone with special needs. This is a big one. We don't made, we're seeing more and more families that are planning or managing the special needs of children or grandchildren. Hold on, somebody just got kicked out. I want to get them back in. Just bear with me a second. Thank you, guys. Okay. So we're see people having to deal with the planning for special needs children or loved ones. They may not just be children. And that this is a big one. And the reason for this is because in many instances, when people have special needs, their special needs include the need often for some sort of governmental assistance. This may be disability or Social Security or Medicaid, whatever that is, they may need it. And receiving an inheritance or any sort of windfall can immediately disqualify them from being able to receive the valuable benefits that they would otherwise be able to receive. But there are strategies and ways to plan in those situations to make sure that your special needs loved one is able to receive without being disqualified for the things that they may need for their life. Okay, so very, very important, and sometimes overlooked. You may also want to think about when it comes to children, grandchildren, special needs loved ones, and anyone that you may be giving care for, about guardianship. Guardianship is something that can be addressed through your planning, and you can say, this is who I would want, this is who is in place, and inform the public of what your wishes are in the event of the need for a guardian to be appointed. Okay, let's go to the next thing. So let's talk about intestacy. I was kind of and feel free again. I just want to remind you, you can put questions in the chat because I know I'm just going. Let's talk about intestacy. I kind of hinted to it a moment ago when we were talking about the blended family situation. But what is intestacy? This is when a loved one dies without a will, without a plan in place, nothing in writing, and they die. And I was just recently looking at the statistics on this. When I first started doing estate planning presentations, which now is probably maybe 8 years or so ago, maybe more. The percentages were around 60% of folks die without a will. 60%, which I already thought was astounding. I recently saw a statistic that said 80% of people in the United States die without a will. I wonder, what do you think the reason for that is? And if you have any idea or what your thoughts are, please put it in the chat. I'm sure there are a ton of reasons, but what do you think? Or what, if you have not, what is the issue? What do you think it is? Is it fear? Is it, do people think that it'll, be cost prohibitive? What are the reasons that people do not have a will, do not have a plan, do not put anything in place? I'm sure some of it is also ignorance. This is part of why I love doing these presentations, because as far as I'm concerned, this, not even from a marketing standpoint, just from the human experience, if people don't have the information, they won't do what they need to do. But in the inverse, if they do have the information, they're far more likely to act in their own best interest. And so it's important to me to make this information available to any and all who will listen. Because I also, in addition to doing estate planning and doing documents and all those sort of things for folks and set them up, the bulk of my practice is actually probate, which is surprising to me still because you don't really market and advertise the probate side of a practice most times, because it's not sexy, so to speak, right? It's not the type of law that people really want to talk about. Why? Because it's the business of death. It's when somebody dies, there are all sorts of things that now your family has to do. And many times they're overwhelmed by the process. Many times they don't want to deal with it because their heart is broken and they're grieving and they don't want to have to also consider how to deal with unwinding what you've left behind, addressing bills and distributing to beneficiaries and making sure they're complying with all of the rules and the laws and all of that. And so they come to me or firms like Betner Gray Law Office to aid with probate. And, I'm very much informed by that side of my practice, which I would say is probably 60% of our clientele. I see one of my paralegals is on. I'm looking at her like, right? We have the bulk of our clients are probate clients. And many times families are coming to us not only because they're overwhelmed with the process, but because they can't agree and because there was no plan put in place. And so I really try to encourage my loved ones, anyone who I get the opportunity to speak to make sure that you are not a part of the 60 to 80% of people who die without a plan in place. Okay. If you die in the state of New Jersey, intestate, the state will decide what happens, not your family, not your wishes. And so what does that mean for you? It means that the state already has a plan. It's already codified in law. It's a statute about what happens to your things if you haven't thought through it. The state says, you know what? Don't worry about it. We got a plan already. And if you don't do it, we'll take care of it. I'm in a few groups on Facebook and I'm in a probate group, and I somebody commented, which I don't love it, but other people who are not professionals, who are not attorneys or financial planners, are in the group, and so sometimes people post questions about their own situation, and I never give legal advisement, but one stood out to me yesterday, and she posted, "My uncle died. He was married when he died. His home." Before he died, he did a quick claim deed and he removed his wife from the deed of the property. And so my question is, does my grandmother get the house and should I hire an attorney? Now remember, this is the niece of an uncle trying to step forward and assert herself in the estate of her uncle. I did comment. I just said you need an attorney. But the state is very clear. There's only a certain person or people who have the right to step forward. It doesn't matter if you were living with that person when they died, if you were their caregiver or their best friend, if you were even their power of attorney. That doesn't matter. What matters is what has been put in place. And if nothing has been put in place and it's an intestate estate, then the state says this is the only person we want to talk to, and there is an order to that. Okay. So ask yourself, do I trust the state to decide for my family? This is something only you can answer, but if you ask me, for myself and my family, the answer is no. So, in the state of New Jersey, and this is very similar in other states as well, and you can look this up. So, if you're not in the state of New Jersey and you want to know, all you have to do is Google what is the intestacy chart in my state. And so you'll write whatever the state is and you put it there. Okay. So if you die without a will in the state of New Jersey, if you have a spouse, the spouse might receive everything. But if it's a blended family situation, which we just discussed, then they have to share it with the children. Okay. Now, if there is no spouse, but there are children, then children inherit equally. Let me tell you how many clients I have in this situation. I won't tell you how many, but there are so many. And this is when a parent dies and there are multiple children who have to now navigate, there is no will, mind you, they have to decide amongst themselves which one of those children is going to step forward as the administrator, who gets to act on behalf of the estate. Now, you can imagine, especially in the instance of adult children, there's always disagreement. There's always at least two who feel like they're the best to act. And because there was nothing in writing to say who actually was the best or who was preferred, now they have to come to get on one accord. And sometimes that happens easily and sometimes it doesn't. When it doesn't happen easily, you know what happens? They have to tag me in and we have to go before a judge, and the judge ultimately either decides amongst the children or will appoint somebody, and that means that the estate is going to have to pay. Okay, so children will inherit equally if no spouse. If there's no spouse and no children, then it goes to the parents of the person who died. If not to the parents, then to the siblings. If there are no siblings, then whoever the remaining relatives are. If no relatives can be found or located, then everything that you've built over your life goes back to the state. Okay, so these are important rules, and I'll be happy to share them with you and this chart that I created because I think that you should know. That's really all. Okay, I just feel like everyone should be aware of what happens when you don't act. Ignorance is maybe bliss right now, but in the long run, it's really not. Okay. All right. So I've already said this, but just to reiterate, these are the kind of problems that arise when you leave an intestate estate, okay? Court involvement, when people can't agree, family conflict, delays, and legal costs. And I will say the investment to get your estate plan done by an attorney may be a few $1,000s, but the probate fees, hiring an attorney to aid you in probate, are probably 2 or 3 times more what you will pay to get an estate plan in place. Okay. And you may be gone, but this is something that you're leaving on your loved ones to handle. Okay. Guardianship also can be very lengthy and an expensive process. Okay. And then it can create a situation where there is no protection instructions for your assets or benefits. And another thing that comes to my office pretty frequently are families who are facing the foreclosure of homes after a loved one has passed away because they didn't do anything, because there was no pre-planning, and those who were living in the house just continued to live there without taking action until the court got involved. Okay. So here are the core legal documents that every adult should have. And I say this all the time. Sometimes people think, well, there's a trigger age that I need to wait until I'm over the age of 50 and then I start planning. No, from my vantage point, every adult really needs to be thinking about all of these documents. At a minimum, at the age of 18, young adults should have a power of attorney and an advanced healthcare directive. Why is this? Because yes, they are still the child of someone, and there's probably an adult that's more adult than them who is advising them and caring for them. But as far as the law is concerned, they are considered adults, which means that no one can speak for them. No one can make decisions for them in the eyes of the law. And so if you as a parent or a young adult want to have yourself or to have your parent or somebody else appointed, then you must do a power of attorney and a healthcare directive. Okay. And then it's very possible, depending on circumstances, that they should also consider a trust. Okay. All right. So let's go to the next slide. So we're going to talk about just some of the basics of these documents. If anything that I have said so far, you want to ask a question about, by all means, please put it in the chat, okay? And I will get to it. So here I say wills, powers of attorney, and living will. In our previous slide, you didn't see the word living will, but the term living will and advanced healthcare directive are used interchangeably to talk about the same document. Okay. I have heard folks come to me in consultation and they're talking about a last will and testament, but they're using the term living will. So just for something, a little nugget for you to remember and walk away with, the last will and testament only stands up after you have died. Okay. It's kind of like you die, it comes to life. While you're living, it's essentially dead. It has no purpose, okay? But a living will that is moving and alive is also alive while you're alive, okay? And so it is talking about your healthcare, your medical choices in the event that you are living, but don't aren't able for some reason to speak for yourself, okay? So let's look at the basics of each one of these documents, okay? So the first one, everybody knows, everybody's familiar with the last will and testament. It is just a legal document, and you've probably seen it. Your loved ones, one or two of your loved ones may have had a will. Maybe you have a will. Maybe you wrote something up yourself. Maybe you got something online from LegalZoom.com or Susie Orman. Many people know what this document is, and it's a good basic document. If you don't do anything else, you need to at least have this. When you put this in place, you immediately cut off all those things we were talking about on the previous slides where the state steps in and takes over. Okay. If you have a will that is executed and done properly, now you have given the instructions to your loved ones and to the state about what you want to happen. Okay. It speaks for you when you can no longer speak for yourself, and you can tell the state, hush, don't say anything for me. I've already made plans. I've already spoken. Okay. It is the simplest document that you can do. If it's done with an attorney, which I think you should do, and the reason for that is it's a lot of reasons. But one of the primary reasons is when people maybe want to contest it. And it is much more difficult to contest a will that has been prepared with and by an attorney. Okay. And if you don't know what I mean by contest, it's if a beneficiary or a loved one or someone that you purposefully did not include wants to say, nope, they didn't mean that. I don't agree with that. I don't think that's real. And they want to go to court, and they will hold up the process. And it's a simple thing to hold up the process, by the way. They can just file something at the surrogate office, and then whoever is supposed to carry out your wishes cannot until it's been addressed by a judge or it's been dismissed. Okay. So you want to make sure that your last will and testament is put in place and that it's done so with an attorney. Okay. It will be your wishes written down. You sign it with two witnesses and a notary, and hopefully an attorney will be there helping you. Okay. An advanced healthcare directive, like we just talked about, also known as a living will, is going to protect your voice while you are living. But if you find yourself in in a medical situation where you cannot speak for yourself, okay. So that is what this advanced healthcare directive does. This is something that I really like to go over with my clients. We go now, every other document, we do more of a general review, but for this healthcare document, we go line by line with my clients. And the reason for that is because I really want them to think about this various circumstances that they might find themselves in and what they would want to do and what they wouldn't want done. Things we cover include what organ donation, include whether or not you would want to have artificial respiration, whether you would want to receive blood and antibiotics, whether you would want to be resuscitated, or if there would come a time when you wouldn't want extraordinary measures taken to keep you alive. Okay, so we deal with all of those sorts of things in the Advanced Healthcare Directive document. And then finally, a power of attorney. I love the power of attorney because it, whether you are incapacitated or not, it's helpful to have somebody who can conduct business for you. I just had a client who just left on, I think, Monday or Tuesday to go out of the country, but there is a pending transaction, a real estate transaction that is happening in the States while they are gone. They don't want it held up. They want the sale to go through without them, and they want to be able to receive their proceeds. So what did they do? They appointed me as their power of attorney. They came into my office. We did a power of attorney that gave me authority, even though they're perfectly well. They are enjoying their life somewhere in a tropical location for a long period of time, but they've empowered me to conduct their business. This is why I love powers of attorney. They really can help you whether you're incapacitated or not. And I think that every adult should have one, at least one person that is appointed and has power that you trust, who can step in and help you with your business. Okay. All right. Now, let's talk about trust. This can be really lengthy. I have a lot of information here, but I'm not gonna spend a ton of time on trust. But I will say this. I think everybody who has any sort of asset needs to consider at least a revocable trust. Why? Because it will avoid the process of probate. We didn't spend a whole lot of time on that, but probate is when a family member or a loved one has to conduct your business under the purview of the court. And this involves oftentimes going to the surrogate's office in your county, and making an application to open a probate estate file. And by doing so, now you've notified the state that you will be the actor for this estate, or your loved one will go and be the actor for your estate. And that means that there's going to be oversight of the state throughout the process. Some people really don't want this. Some of that oversight also includes being bonded. This is a common fact that many people, most families, I'll even say, that have come to my office don't know. So when you do a will and you're appointing someone to be an executor, you should also be considering whether that person has financial acumen, how is their credit. You may not know all of that, but if you can either ask or gauge from how they conduct their life, that is something to be mindful of, because the bonding process is an application at an insurance company to issue an insurance bond that covers the executor in the event that they do something or have a misstep and a beneficiary has a problem with it. They can file a claim and they can be compensated for something that went wrong in the probate process. But in order to be qualified for a bond, they have to pass a credit check. They have to have the financial capabilities to do so. Okay, so this is something to be considered when drafting your estate plan documents. And I have had families who have come to me with multiple executors who could not get bonded, whose finances would not permit. And so what we do next is we have to go to the judge. We have to ask a judge, will you allow this family to go forward with probate without the requirement of bond? And I've had judges say both. I've had judges, some say okay because there aren't many assets, and I've had judges say no. You're just going to have to find somebody else. So this is just something to be mindful of, and why I like trusts, because if a trust is done, this is not a requirement at all. Nobody has to go to the surrogate's office. You don't have to make an application. You don't need the oversight of the state, and no one has to be bonded. Your trustee can start acting right away. Okay. A trust agreement looks just like a will. It's just a writing. It's just a piece of paper that is kind of like a contract, where you, as the individual establishing the trust, or also known as the trustor or settler, will set up this document and you'll say, this is who I want to be my trustee. These are who I want to be my beneficiaries. And this is how I want everything handled. And when you die, your trustee does not have to go through any process. They can just start doing whatever you've asked them to do. This is in the event of a revocable or an irrevocable trust. Okay. So that's why, to me, trusts are like gold. Yes, you pay a little more, but they start working while you're living, and they keep working after you die, and they make things smooth. Okay. If done correctly. All right. Revocable, I just want to say really quick, revocable versus irrevocable. Revocables are more accessible financially, and the person who starts a revocable trust maintains all control. So some people love that because some people, I'm not going to say me, but some people have control issues and they don't want to relinquish control of their assets in any sort of significant way. And so a revocable trust gives a lot of what you want from a trust without having to relinquish control. But it also means that the assets that are put in a revocable trust are still a part of your estate until you die. So that means if you have creditors during your lifetime that want to attach to something, that have judgments against you, and they want to attach to some of your assets, they can do that. Your assets are not protected by that revocable trust. Okay. On the other side, we have the irrevocable trust, much more strict. You do have to relinquish control to someone or an entity that you hired, someone you trust or an entity that you've hired. But it gives another level of protection. So anything that you move into an irrevocable trust now is no longer a part of your estate. So why do people who want to maintain their wealth and pass down houses and things like that to the next generations think about irrevocable trust? Is because now these assets, it's after 5 years, are no longer well, first of all, are immediately not considered a part of your estate anymore. All right, so they're not a part of your calculable estate. But the 5 year thing I was going to talk about is as it relates to governmental benefits and Medicaid. So when you, God forbid, you need to apply for long-term care with Medicaid, they look into your finances and they only go back 5 years. So they look to see if you sold property, how much money you have, how many assets you have, to determine if you're eligible for governmental assistance. And if you've moved your assets out of your name and you put it in an irrevocable trust 6 years ago, 7 years ago, whatever you have there, it doesn't count and it never has to be sold or spent down. And you can qualify for whatever governmental benefits that you may need without essentially stealing from yourself and taking from generations to come. Okay. So we only have a few more minutes. So I just want to, I know this is the key question. Everybody wants to know, how much is it going to cost me? I don't really have money for this, and I understand, but the truth is, you probably don't have what you would have to spend if you don't plan. Okay, and that's whether you're living or whether you've been gone. And trust me, once you die, whatever you do have left, your family is going to spend it if you have not given instructions for it. And they're going to, and if they have to spend it on hiring an attorney, they'll spend it on that too. And countless families that come to me, that's where the money's coming from when they hire me. It comes right out of whatever was left behind. Okay. So the investment is in peace and in protection of what you've built and of your loved ones and of making sure that you can try to help your loved ones avoid as much heartache as possible because their hearts are already going to be broken, either whether it's because you're gone or because you aren't able to do what you've done for the bulk of your life. Okay. And so because we love the people that we love, because we love our loved ones, because we love the people who've been entrusted to us, we should plan and we should see the value in whatever the investment is. Okay. So a basic estate plan, which will include a will, power of attorney, a healthcare directive, may run you about $2,500 to $5,000, depending on where you go and who you hire and all of that, and what all it also entails, and the complexity of your life and your circumstances. Any plan that involves a trust, I tell people, a trust by itself, a revocable trust, often start just by itself with no other documents, usually you're somewhere around $3,500 to $4,000. Anything lower than that is probably not worth the paper it's written on, I'm telling you. But the value that it brings to you is extraordinary. Okay. All right. So a trust base or legacy plan often can run anywhere from 5,000 or 3,500 if it's just the trust. But if it includes other documents that we discussed, like the living will, the power of attorney, a pour over will, which I do with every trust package that I do, you want to expect that the cost is going to be somewhere around 5,000 to 10,000. It could be more. And of course, any sort of advanced and more complex planning, the fees can go up. Special needs trust, we talked about special needs. That is a special kind of trust. That's a trust that makes sure that your special needs loved one can receive and can be cared for during their lifetime. But at the time of their passing, Medicaid is entitled to, or the government is entitled to, whatever is left. And so it has to be done correctly. This is something that I started doing early in my practice because of a dear member of my church who approached me and said, "Can you do a special needs trust?" And I wasn't even confident that I could do it. I was a baby lawyer. And she said, "Listen, my attorney began drafting one for my loved one, and he died. And I believe that you can do it. And I'll even give you the work that he already did." And so she empowered me. She believed in me. And that's how I started doing special needs trusts. And so that is something that I know very a lot about. And I'm excited to help families when they need to have this type of work done. Okay. But what you should remember is that planning ahead is almost always less costly financially and emotionally than crisis, court, or conflict later down the line. Okay. All right, let's see where we are here. If you have questions, again, put them in the chat. All right, so what step do you know deep down that you need to take next? And you don't have to write this in the chat because I already know you guys don't want to. But really, honestly, think about it. What step is it time for you to take? And this may just be an inventory. Inventory, think about it. Just start. I have a note in my phone, like I mentioned to you. I have multiple, but I have one where I really started addressing all sorts of things, not only finances, but things that I want to say to loved ones, things that I would want them to even read from me when I'm no longer here, instructions and recipes and where I bank. What have you taken inventory of your life and of your estate? And if you were not here, or if you suddenly couldn't work and were disabled, what happens next? Okay. So what step do you know deep down that you need to take? If you feel comfortable putting in the chat, by all means you can. If not, I would say just write it down, put it somewhere, and start with an inventory of your life. I think my slides are out of order, but that's okay. Thank you so much for your time listening. I want to open up for some questions, but I want you to also remember nothing is impossible. I was telling my son the other day about something that I wanted to do, and I'm just like, I want to, but it really is impossible. And he said, no, he said, impossible really is only I'm possible. And I really, really love that. And so I want to say that to you. It may seem like it's hard, it's cost prohibitive, but I want you to reframe how you're thinking. If you can plan to go on a trip, if you can plan to go on a cruise, if you can, plan to purchase those designer purses and shoes, then you by all means can plan to invest in your legacy and for your loved ones.